This podcast is for educational and informational purposes only. It is not medical advice, legal advice, or professional advice of any kind. And it does not create an attorney-client, physician-patient, or other professional relationship. Any discussion of cases, outcomes, standards of care, statutes, or regulations is general in nature, may be incomplete, and may vary by jurisdiction and over time. Listeners should consult their own attorney, malpractice carrier, risk manager, or qualified clinician for advice on any specific matter. Any case discussions are based on public records, de-identified information, or educational reconstruction. The views expressed are those of the speakers and do not necessarily reflect the views of any employer, hospital, health system, insurer, or affiliated organization.
Welcome back to On the Record. Last episode, we told you the story of a patient we called Daniel, a real man experiencing a real medical crisis at a real hospital. He called 911 with chest pain. He made it to an emergency room. He received rapid care from a team that recognized his condition within minutes. And despite that, he passed away. Today, we're shifting our lens entirely. We're leaving the bedside behind and entering the courtroom. This is the lawsuit that followed. Over the next 3 episodes, we're going to walk you through the legal machinery of a major medical malpractice verdict, the complaint, the discovery battles, the expert armies, the depositions, the pretrial motions, and finally the trial itself. But today, episode 2, is about the foundation. How does a patient's death become a legal case? What happens when the family retains lawyers and files a complaint? And what happens when the hospital says we met the standard of care?
Roughly 16 months after the patient's death, a complaint was filed in the state circuit court. The plaintiff, the patient's surviving wife, acting as personal representative of his estate, named 2 defendants, the hospital system and the interventional cardiologist who had been on call for the catheterization. The original complaint focused primarily on what happened in the catheterization lab, the airway emergency, the intubation and extubation, and the code blue response that followed. It alleged that the care team failed to have a supervising physician present at the patient's arrival, that the intubation was mishandled, that the breathing tube was removed without confirming placement, and that the code blue was chaotic and inadequate. The complaint also identified the treating physicians individually and named them alongside the hospital system.
Let me break down what those early counts alleged, because the structure of the complaint tells you what the plaintiff's initial case theory was. Count 1 alleged negligence against the hospital system itself. Count 2 alleged active negligence against the interventional cardiologist individually. At this stage, the focus was on Phase 3, the cath lab crisis. The complaint alleged that there was no supervising physician present at the patient's arrival, the breathing tube was placed, but was unable to be confirmed by end-tidal CO2 monitoring, so it was removed. And the code blue response that followed involved multiple failed reintubation attempts over roughly 20 minutes without an anesthesiologist present and without activating the difficult airway response team. The arrest record was only partially completed and failed to document key participants and timing.
This is important for physicians to understand. The original complaint was focused on the cath lab, on what happened from the moment the patient arrived at the regional medical center. It was alleging that the airway management and resuscitation were negligent. It wasn't yet making the broader argument about the hospital system's transfer protocols or the decision to accept a STEMI patient at a facility without catheterization capability. That broader theory, the system-level failure, would come later, after discovery opened up and the plaintiff's experts had a chance to review the full record. We'll get to that expansion in a few minutes.
The defendants had a statutory window to respond to the complaint. Weeks later, the hospital system and the interventional cardiologist filed their answer. They denied the allegations, but they also raised affirmative defenses. Legal arguments that even if the facts alleged were true, the law would shield them from liability. The most significant defense was the state's Good Samaritan statute.
The Good Samaritan Act creates a legal shield for healthcare providers who render emergency care. Under the statute, the standard of liability is not ordinary medical negligence, it's reckless disregard. Reckless disregard is a substantially higher legal bar. It means the defendant consciously disregarded a known, substantial risk to the patient's life. It's more than a mistake. It's more than a deviation from the standard of care. It's indifference. The defense invoked this statute, arguing that even if the hospital system's conduct fell short of the standard of care, it didn't rise to the level of reckless disregard. The plaintiff had to prove not just that the hospital deviated from accepted practice, they had to prove that the hospital knew a patient could die if they acted as they did, and they acted anyway. That's a significantly higher burden of proof. It's worth flagging now that this defense might ultimately come back to harm them. We'll see how that plays out at trial.
The other defenses were more standard: contributory negligence, fault of non-parties, statutory damages caps. But two things stood out as the centerpieces of this case's legal strategy. The Good Samaritan Act was one, the other was EMTALA, the Federal Emergency Medical Treatment and Labor Act. Both sides would use EMTALA to support their positions, and it would become crucial to how the plaintiff's expert framed the case. We'll get into the specifics of EMTALA when we discuss that expert's deposition testimony, but flag it now. It matters.
After the complaint is filed and answered, both sides enter discovery, the phase where they exchange evidence. Medical records are produced, expert reports are exchanged, interrogatories, written questions requiring written answers are filed, and both sides begin deposing the other side's witnesses. In this case, discovery was contentious. Over several years, the plaintiff filed multiple motions to compel. legal filings demanding that the defendant produce information the plaintiff believed hadn't been fully provided. The court granted some of those motions. The defendant filed motions for protective order, seeking to shield certain discovery from the plaintiff on grounds of privilege or scope.
Discovery disputes are common in complex medical malpractice litigation. Both sides have legitimate reasons to push back. The plaintiff wants everything that could support their theory of the case. The defense may object because the requests are overly broad, because the material is privileged, or because what's being asked for doesn't exist in the form requested. Courts sort these disputes out, and in this case, the court ruled on several of them over time. What matters for our purposes is that contested discovery, regardless of why it happens, can shape how the evidence is perceived once it reaches the jury. Jurors don't typically hear about the motions to compel themselves, but the dynamics of a hard-fought discovery process can affect the completeness and presentation of the evidence they do see. And if a judge issues an adverse inference instruction, telling the jury they can draw negative conclusions from missing evidence, that's powerful.
The medical records that were produced contained gaps and inconsistencies. The timeline of what happened in the cath lab had multiple versions, depending on which provider wrote the note. Times in the aircrew's documentation didn't align with the hospital's records. The arrest record was only partially completed.
I want to talk about this from a clinical perspective because this is something every physician and nurse listening has dealt with. We've all been in a chaotic emergency where resources and staff are limited, and there may not be any one person keeping a log and tracking times. If you have 2 providers and a patient in cardiac arrest, your focus is on the patient, not on documentation. That's normal, that's expected. But here's what matters. Once the chaos has resolved and the team has assembled, once everybody has a role, make sure someone is keeping time. And after the event, while things are fresh in everyone's mind, sit down together and document. Not to coordinate stories, to get the facts right. Because if you don't, 5 years later, a plaintiff's attorney will point to the gaps between your note and the nurse's note and the flight crew's note, and they'll tell a jury that the care was chaotic and uncoordinated and didn't meet the standard of care. In reality, the care probably did meet the standard of care. But at trial, the documentation tells the story, and the jury will likely listen to that version. I'm supportive of providers in these scenarios. I've been there myself, but I want you to protect yourselves. Document while things are fresh. Make sure everyone's part of the documentation process is complete before leaving the case. Otherwise, it can and will be used against you.
As discovery unfolded and expert reports came in, the plaintiff's case theory evolved. The original complaint had focused primarily on the cath lab crisis, the intubation, the extubation, the code blue. But as the plaintiff's experts reviewed the hospital records, the transport timeline, and the system's protocols, they began to suggest something bigger. They saw what they alleged were multiple opportunities to get the patient to a catheterization lab faster. And at each decision point, the system followed a path that kept the patient at a facility without that capability. More than 2 years after filing the original complaint, the plaintiff filed a second amended complaint. And it was much broader. It added allegations about the decision to accept a STEMI patient at a facility without a catheterization lab. It added allegations about the delay caused by the helicopter needing to burn fuel before transport. It added allegations about the failure to use ground transport as a backup. The complaint now articulated a 3-phase alleged system failure, not just a single clinical disaster in the cath lab.
This expansion is strategic. By amending the complaint to allege system-level failures, the plaintiff widened the aperture. The original case was about what the interventional cardiologist and the cath lab team did or didn't do. The amended case was about the hospital system's protocols, the hospital system's decisions, and the hospital system's alleged indifference to getting a STEMI patient to definitive care by the fastest possible means. It's the difference between blaming a physician and blaming the institution.
And this is where the plaintiff's expert team reshaped the narrative. The amended complaint didn't happen in a vacuum. It happened because the plaintiff's experts, particularly an emergency medicine physician from a major academic medical center, were offering opinions that the case was bigger than the cath lab. They alleged that the hospital system's transfer protocols failed the patient at 3 different phases of care. Those are allegations, opinions offered by retained experts, not established facts. But they were compelling enough for the court to allow the amended complaint to proceed. The defense opposed the amendment, but the court permitted it.
By the time the amended complaint was filed, both sides had assembled expert teams. The plaintiff's expert lineup included an interventional cardiologist to testify that the cath lab care breached the standard and caused the death. They retained an emergency medicine physician from a major university, a professor who directs a center for resuscitation science and participates in developing international CPR guidelines, to opine on the community hospital and transport failures, the code blue response, and causation. They brought in an anesthesiologist and critical care physician to testify about airway management, the decision to extubate without confirmed placement, and the absence of an anesthesiologist at the arrest. And they hired nursing experts to testify about nursing care failures, scope of practice concerns, and record keeping. The defense brought their own team, an interventional cardiologist from a VA medical center to support the cath lab care, an emergency and flight medicine physician to defend the community hospital and transport decisions, a critical care physician to defend the resuscitation, and the hospital system's own chief medical officer as a corporate representative to defend the system's policies and practices.
Both sides retained credible experts to support their positions. The plaintiff assembled academics from nationally recognized institutions. The defense assembled experienced clinicians who practiced medicine and could speak to the standard of care from the bedside perspective. That's how litigation works. Both sides bring their strongest voices to make their case.
As experts engaged and depositions happened, the case continued to evolve. The plaintiff filed motions requesting policies and procedures, transfer protocols, helicopter dispatch criteria, protocols for when to use ground versus air transport, policies for extubation, code blue response guidelines. Some documents were produced, some weren't. The plaintiff alleged that the hospital system operated a model where its community hospitals funneled patients into its central regional medical center for higher-level care, rather than redirecting to the nearest capable facility regardless of affiliation. This model, the plaintiff alleged, created a preference for keeping patients within the system's network. It should be noted that this is an allegation. The plaintiff did not present direct evidence of a financial incentive.
The defense acknowledged that they operated through a centralized transfer center that coordinated flow from their community hospitals to their tertiary center. They argued this was actually more efficient, that transferring within the system was faster than the alternative, which would require the community hospital to contact a non-affiliated hospital's transfer center, then formally request physician acceptance, then arrange a separate ambulance. The defense presented evidence that interhospital transfers between unaffiliated hospitals take time. Their argument, we got this patient to the cath lab as fast as the system could. And from a pure timing perspective, the defense had a point. Even with the helicopter delay, the patient arrived at the cath lab within approximately 100 minutes of first medical contact, inside the ACC/AHA's 120-minute benchmark for transfer STEMI cases. The system identified the STEMI, accepted the patient for transfer within minutes, and got him to the catheterization lab. The question isn't whether the system was slow, it's whether there was a faster alternative that should have been pursued.
The plaintiff countered with expert testimony that inter-hospital transfers, affiliated or not, happen routinely without significant delay. That's the expert's opinion, and it may not generalize to every region or every clinical scenario in the way he alleged, but he was allowed to offer it. The plaintiff also alleged that if the patient had been transferred by ground ambulance or diverted from the emergency department to a closer PCI-capable facility, he would have been in the cath lab sooner.
I want to step back and give you my clinical perspective on this because I think it's important. Guidelines are just that, a guide. They don't replace our judgment. We can override the guideline or transfer protocol in place when clinical circumstances demand it. But in this case, the transfer system actually worked efficiently. The patient was accepted for transfer quickly. If it hadn't been for the helicopter needing to burn fuel, he would have arrived within an appropriate time. I don't think the physician at the community hospital played a role in any alleged system failure. The system is in place to offload the transfer logistics from the ED physician so she can continue focusing on all her emergency patients. That's how it's supposed to work. But this is clearly what the plaintiff is focusing in on, so we need to be aware of the policies and guidelines in place. And I want to be clear about something. There is no evidence in the record that the hospital system had a financial incentive to keep this patient in network. We don't know this patient's insurance status. The teaching point here is simpler. Know your transfer options. Know which facilities around you have catheterization capability. Know how long ground transport takes versus air. And if your protocol doesn't get a STEMI patient to a cath lab fast enough, you have the clinical authority to override it. That's the lesson.
As the case broadened, a critical legal question emerged. The plaintiff was now alleging that the hospital system should have redirected EMS to a PCI-capable hospital. The defense countered with a statutory argument. EMTALA, the Federal Emergency Medical Treatment and Labor Act.
EMTALA is a federal statute that imposes obligations on hospitals with emergency departments. It has 3 core requirements. First, when a patient comes to the emergency department, and the regulations define that as presenting on hospital property, the hospital must provide a medical screening exam. Second, if that screening exam reveals an emergency medical condition, the hospital must provide stabilizing treatment within its capability. Third, if the hospital can't provide definitive treatment, it must arrange an appropriate transfer, meaning the receiving facility has agreed to accept, the patient is stabilized to the extent possible, and appropriate transport is arranged. The entire purpose of EMTALA is to prevent patient dumping, hospitals turning away emergency patients or transferring them without stabilization. The defense's argument was straightforward. Once the ambulance arrived at the community hospital, once the patient was on hospital property, EMTALA was triggered. The hospital was legally required to provide a medical screening exam. Once that exam revealed a STEMI, an emergency medical condition, the hospital was required to stabilize the patient. And this patient was hypotensive, his blood pressure was dropping, making stabilization all the more critical before any transfer. The hospital then arranged an appropriate transfer to a PCI-capable facility. The fact that they chose their own regional medical center rather than a non-affiliated hospital didn't violate EMTALA. The statute doesn't require transfer to the closest facility. It requires transfer to an appropriate facility that has agreed to accept.
The plaintiff countered with a different interpretation. They alleged that the ambulance, at the moment EMS notification was made to the community hospital, had not yet physically arrived on hospital property. Under EMTALA regulations, the hospital's obligations are triggered when a patient comes to the emergency department, which the regulations tie to hospital property. The two sides disagreed over where the ambulance was in relation to hospital property at the moment of notification, and whether EMTALA had been triggered at that point. But here's what's important to understand about the reality of this situation. The STEMI was identified 2 minutes before arrival. 2 minutes. Whether the ambulance was technically on hospital property or approaching it, the window was extraordinarily narrow. This disagreement shows just how close the call was either way, and just how difficult a scenario everyone involved was placed in. And here's what's important to understand clinically. It's difficult to imagine a scenario where the ED physician or anyone else would divert an ambulance that is arriving imminently at your hospital. And there's a reasonable concern that diverting a hemodynamically unstable patient without performing a screening exam and stabilizing first could itself be an EMTALA violation. That is exactly the kind of patient dumping the statute was designed to prevent.
The plaintiff's expert made a specific argument in his deposition. He stated that the emergency physician could have performed a medical screening exam from the ambulance bay, confirmed STEMI, and then diverted the ambulance to the PCI-capable hospital without formally accepting the patient for evaluation. Essentially, a screen and redirect at the door. Under his interpretation, you could satisfy the screening exam requirement and still send the patient elsewhere without going through the full stabilization and transfer process. This is a legally contested interpretation. Under the statute, once you perform a medical screening exam and identify an emergency medical condition, which a STEMI is, the hospital is obligated to either stabilize the patient within its capability or arrange an appropriate transfer. And an appropriate transfer under EMTALA has specific requirements. A physician must certify that the medical benefits of transfer outweigh the risks the receiving facility must agree to accept. An appropriate transport must be arranged. What the expert described, screening at the ambulance bay and redirecting the ambulance without going through the formal stabilization and appropriate transfer process, bypasses those requirements entirely. That's closer to the kind of patient dumping EMTALA was enacted to prevent. The defense would argue that what the expert described is not something the law allows, and that their transfer protocols were specifically designed to comply with their EMTALA obligations.
EMTALA is invoked a lot in emergency medicine but understood by few, including, in my view, some of the expert testimony in this case. Here's what matters practically. Once you perform that screening exam and you identify an emergency condition, you are obligated to stabilize and transfer. You can't just see the patient at the ambulance bay and send them on their way. The law doesn't work that way. Now, reasonable people can disagree about the edges, about what constitutes coming to the emergency department, about whether a 2-minute window of STEMI knowledge is enough time to redirect an arriving ambulance. But the core statute is clear: screen, stabilize, transfer appropriately. The hospital in this case did all three. Whether they should have done it faster or to a closer facility, that's the legal question. But the claim that the ED physician could have examined the patient and diverted the ambulance without accepting him for care is, at minimum, a contested interpretation that most emergency physicians I know would view skeptically.
Let me take a step back and summarize where each side had positioned themselves as the case approached trial, because the case had evolved considerably from where it started. The plaintiff's theory had become this: the hospital system accepted a STEMI patient at a facility without catheterization capability. Rather than immediately redirecting EMS to a closer PCI-capable facility or initiating ground ambulance transport, as a backup, the system waited for a helicopter that needed to burn fuel, a delay of roughly 23 minutes. The patient spent over an hour at a facility that couldn't treat his condition. Then, when the patient finally reached the cath lab at the regional medical center, there was no supervising physician present, the airway was mishandled, the breathing tube was removed without confirmation of placement, the code blue response was delayed and poorly coordinated, and the patient died. The plaintiff alleged this was a system-wide failure, not just a cath lab error.
The defense's theory was different. They argued that once the patient was arriving by ambulance, EMTALA was triggered. The hospital was obligated to perform a medical screening exam, and following that exam was required to stabilize the patient, which they did. They were then obligated to arrange an appropriate transfer, which they did, quickly and efficiently. They argued their transfer center coordinated the process. The interventional cardiologist accepted the patient within minutes, and the patient was transported to the PCI-capable facility. The policies in place were designed to comply with EMTALA and to effectuate a quick and smooth transfer process. The care, including the airway management decisions, represented medical judgment under emergency circumstances. And the patient's death was the result of the disease process, an acute STEMI affecting a large area of the heart, not the care provided. And they invoked the Good Samaritan Act. This was an emergency. The patient could arrest at any moment given the STEMI he was experiencing. The state statute exists to protect emergency care providers given the critical nature of these patients and the split-second decisions they have to make. Even if there were deviations from ideal practice, those deviations didn't rise to the level of reckless disregard.
So the jury would have to decide, is this a case of a hospital system that made reasonable emergency decisions under EMTALA constraints and the pressures of an acute STEMI? Or is this a case of a system that, despite having options, followed a path that delayed definitive care for a patient who was running out of time?
Before trial, both sides filed motions requesting that the judge rule on evidence and legal issues in advance. The hospital system filed 7 motions in limine, legal requests to exclude certain evidence from being presented to the jury. The plaintiff filed motions of their own.
These motions tell you what each side was concerned about. Both sides were trying to exclude testimony they believed was inflammatory or appealed to emotion rather than the facts of the case. The defense's first motion asked the judge to limit the testimony of the plaintiff's emergency medicine expert. The defense argued that he was offering opinions far beyond his core expertise. He's board certified in emergency medicine and his academic focus is resuscitation science. But in his deposition, he went well beyond resuscitation. He criticized the ED physician's care. He opined on whether the patient should have been diverted from the ambulance bay, a question that implicates EMTALA, hospital logistics, and transport system design. He drove a rental car between hospitals and timed the drives with an app, then testified that ambulances could go faster. The defense argued that some of these opinions, particularly his statements about what the ED physician should have done with respect to diversion, were inflammatory and did not accurately represent what the law allows. The core issue for the defense was this. The expert's deposition contained statements suggesting that the ED physician could have performed a screening exam from the ambulance bay and diverted the ambulance without accepting the patient for care. The defense argued that this testimony misrepresented EMTALA and would mislead the jury into believing the hospital had a legal option that it actually did not have. The plaintiff's case rested heavily on this expert, and the defense wanted the most inflammatory portions of his testimony excluded.
The defense also filed a motion specifically about EMTALA. They wanted the judge to rule in advance on how EMTALA applied to the facts, essentially, to establish that the hospital's acceptance and transfer of the patient complied with federal law
There was also a motion targeting reptile theory, a trial strategy used by some plaintiffs' attorneys where they frame medical care in terms of safety, following the safety rules, doing the right thing versus the wrong thing. The defense cited case law arguing this framing is subtle coercion, asking jurors to decide based on personal values and community safety rather than technical medical evidence. The defense wanted the judge to prohibit this language.
The pretrial motions are where each side is trying to shape what the jury hears. Both sides do this, it's part of the process. But what stood out to me in this case was the fight over the plaintiff's emergency medicine expert. He's a credentialed physician. A jury would naturally view him as an authority. And when he uses language like safety rules and right thing versus wrong thing, that's persuasive to lay people, even if physicians listening to his testimony might disagree with some of his specific opinions, particularly around EMTALA and diversion. The defense had a strong argument that some of his statements weren't grounded in what a reasonable physician would agree with. But whether the judge would agree, that's what episode 3 is about.
The key experts were deposed during discovery, and those depositions were made available to both sides through the pre-trial motion filings. These recorded testimonies, given under oath but outside the courtroom, would shape what the jury ultimately heard. The plaintiff's emergency medicine expert's deposition was extensive. He's board certified in emergency medicine, and his academic focus is resuscitation science. He testified about his driving trips between hospitals, his opinions on EMTALA compliance, his criticism of the community hospital's handling of the patient, his analysis of the Code Blue response, and his conclusions about causation. The defense objected to portions of his testimony on the grounds that it went beyond his specialty into areas like transport logistics and hospital system design.
The expert used language in his deposition that the defense knew would be powerful with a jury. He used phrases like right thing and wrong thing. He said the errors were so egregious, he would use the word reckless. He opined that the patient could have received a medical screening exam and been diverted from the ambulance bay, a claim the defense argued was inconsistent with EMTALA. The defense would say his statements were not grounded in what a reasonable physician would agree with, that he misrepresented the legal framework, and that his testimony was inflammatory. Whether you agree with the defense or the plaintiff on that, we'll walk through the actual deposition excerpts in episode 3, and you can judge for yourself.
The hospital system's chief medical officer was also deposed. His deposition was the most contentious in the case. The defense filed multiple scope objections, disputes over whether certain questions were appropriate. Dozens of pages of his transcript were designated for trial use by both sides, meaning both the plaintiff and the defense wanted his testimony heard. But they were fighting over which excerpts the jury would see and in what context.
When a corporate representative like the chief medical officer is deposed, both sides need him. The plaintiff needs him to establish what the hospital's policies actually were and whether they were followed. The defense needs him to explain the policies and defend the institutional decisions. The fact that the deposition was so contentious, multiple scope objections, extensive designation battles, tells you his testimony was important to both sides.
Other key depositions included the air crew nurse who intubated and extubated the patient in the cath lab. His testimony about what happened during the handoff, who was in the room, what was said, why the decision was made to remove the breathing tube, was critical. And the nursing staff present at the arrival and during the Code Blue provided testimony about the sequence of events and the coordination of care. By late fall of the 4th year of litigation, discovery was largely complete. The motions in limine had been briefed, and the interventional cardiologist who had been named as an individual defendant in the original complaint, was voluntarily dismissed from the case. That left the hospital system as the sole remaining defendant. Jury selection was scheduled for the spring of the 5th year after the patient's death. The case would go to trial before the state circuit court judge who had presided over the case from the beginning.
Think about that timeline. A patient dies. The complaint is filed over a year later. Discovery warfare happens for years. Experts are retained, deposed, and fight about their scope. Motions in limine are briefed, and not until nearly 5 years later does a jury of laypeople sit down to hear the case. This is the reality of modern malpractice litigation. It takes years. The memory of what happened fades. The defending physicians have moved on. The depositions become the story the jury hears, not the live witness's recollection. In our next episode, episode 3, we focus on the expert testimony. We'll walk through the deposition that the judge had to rule on before the jury heard it. We'll look at the EMTALA arguments in detail. We'll examine the plaintiff's trial strategy, the reptile theory framing, the safety rules language, and we'll get into whether the expert's opinions hold up under scrutiny. Before we close, I want to pull out a few clinical and practical lessons from the discovery phase of this case, because what happens in discovery shapes everything that follows. First, your medical records will be used. In this case, conflicting timestamps between the aircrew and the hospital, a partially completed arrest record, and narrative notes written hours after the event by providers who couldn't remember exactly what happened. All of those became evidence that something was disorganized or forgotten. I want to be sympathetic here because I've been in these situations. When you're in a code with limited resources, you're focused on the patient, not on the clock. That's the right priority. But once the team assembles and roles are assigned, once you have enough people, make sure someone is recording. And after the event, while things are fresh in everyone's mind, document together, not to coordinate stories, to get the facts right while you still remember them. I'm supportive of the nurses and physicians who provide emergency care in these critical moments. I want to keep them from having to defend the care they provided because of documentation gaps. Second, we all have structured code blue teams with dedicated roles for a reason. It's for this exact situation. So once you have a team at the bedside during a code, make sure everybody has a role. If you only have 1 or 2 providers focus on the patient first, that's always the priority. But as resources arrive, assign the recorder, assign the medication nurse, assign the team leader. These structures exist because a jury will evaluate your code response based on whether it looked organized. An organized code that's documented in real time is defensible. A code where 5 providers each wrote their own note from memory hours later. That's what creates the timeline conflicts that plaintiffs use at trial. Third, expert evolution is normal, but it shapes the case theory. The plaintiff's original complaint focused on the cath lab. The amended complaint expanded to include the community hospital phase and the transport decisions. That expansion happened because the plaintiff's experts said there's more to this story. The defense opposed the amendment, but the court allowed it. And once it was allowed, the case became about the entire system, not just the individual physician. For defense counsel, that's a strategic turning point. Fourth, EMTALA is invoked a lot, but understood by few. Both sides used EMTALA in this case to support their position. The defense said EMTALA required acceptance. The plaintiff said EMTALA didn't prevent diversion. The reality is that EMTALA is primarily an administrative statute. It exists to prevent patient dumping, and its core requirements are screen, stabilize, and transfer appropriately. EMTALA compliance doesn't insulate you from malpractice liability, but EMTALA violations carry serious consequences: civil monetary penalties and potential Medicare exclusion. Good medicine, good documentation, and good clinical judgment, Those are what protect you. EMTALA provides a framework, but it's not a shield and it's not a sword. One more thing before we move to trial. The defense invoked the Good Samaritan Act as their primary legal shield. Under that statute, the standard isn't ordinary negligence, it's reckless disregard. That's a high bar. The statute exists because emergency medicine is inherently high risk. These are critically ill patients. Decisions happen in seconds, and the legislature recognized that holding emergency care providers to the lower standard of ordinary negligence would discourage physicians from taking emergency calls. That's the purpose of the statute. In Episode 3, we'll examine the expert testimony in detail and see how the judge ruled on what the jury could and couldn't hear. Those rulings shape the trial in ways that matter.
The Good Samaritan Act protects emergency care providers, but protection has limits. The statute raises the bar, it doesn't eliminate it. If a jury concludes that conduct crossed the line from negligence into conscious disregard of a known risk, the statute doesn't help. It just changes the question the jury has to answer.
That's what we'll see in Episode 3, how the expert framed the case, how the judge ruled on what the jury could hear, and where this case goes from there.
So here we are. The complaint alleged failures at 3 phases of care. Discovery revealed gaps in the medical records. Experts lined up on both sides. Depositions were taken and fought over. Motions in limine were briefed. And a jury was impaneled to decide a question that no physician wants to face.
Next episode, we enter the courtroom. We'll walk through the expert testimony, the testimony that was allowed and the testimony that was excluded. We'll look at the trial strategy that the plaintiff used to frame the case. We'll examine the judge's rulings on the expert's deposition and talk about what was allowed, what was excluded, and why it matters. And we'll reach the conclusion of this case. That's ahead in Episode 3, the expert testimony, the judge's pretrial rulings, the EMTALA argument that both sides invoked, and the verdict that followed.
This is On the Record. We'll see you in Episode 3. This podcast is for educational and informational purposes only. It is not medical advice, legal advice, or professional advice of any kind. And it does not create an attorney-client, physician-patient, or other professional relationship. Any discussion of cases, outcomes, standards of care, statutes, or regulations is general in nature, may be incomplete, and may vary by jurisdiction and over time. Listeners should consult their own attorney, malpractice carrier, risk manager, or qualified clinician for advice on any specific matter. Any case discussions are based on public records, de-identified information, or educational reconstruction. The views expressed are those of the speakers and do not necessarily reflect the views of any employer, hospital, health system, insurer, or affiliated organization.